We're good to go now. Welcome all of you to Monique and Roland Vale People's Academy of International Law. As stated recently by UN Special Rapporteur Francesca Albanese, we cannot rely on states, the UN, or regional bodies to save international law. International law can only be saved and effectively implemented and enforced by people like you, who learn the law, who share their knowledge, who apply the law, and cite the law before domestic, international, and regional courts, and insist on adherence to international law by your own and other states. So thank you very much for being here. My name is Gail Davidson. I am filling in for Marjorie Cohn, Dean of the People's Academy, who is ill today. Our course 6 is on the protection of human rights in the inter-American, African, and European systems. Our 3 faculty today are Bill Bowering, Walter Antion, and Stanislas Ajong. Each of them will speak for 40 minutes. Then they will comment on each other's presentations, followed by questions from you and answers from the faculty. We have French, Spanish, and English translation. Please put your questions in the Q&A box for our discussion. Bill and Stanislas will speak in English and Walter in Spanish. Click on Interpretation at the bottom of your screen and choose your language. Within the next few days, we will post on our peoplesacademy.net website the faculty presentations in English, French, and Spanish with links to relevant articles. The regional human rights systems serve an important function in the promotion and protection of human rights. The European, Inter-American, and African systems each play a significant role in defining and protecting human rights by identifying state duties to protect rights and determining state responsibility for violations alleged in complaints that can be submitted by both groups and individuals. Each of these regional systems has its own treaties and other instruments, its own courts, tribunals, monitoring bodies, and enforcement mechanisms. Member states of the regional systems may be found accountable for violations of human rights caused by domestic laws or policies or by state agents. This course will critically examine the inter-American, European, and human rights systems. Now I'd like to introduce to you our 3 faculty. Professor Bill Bowering has taught human rights and international law at Birkbeck College, University of London since 2006. He entered academia in 1990. As a practicing barrister since 1974, Bill has represented applicants at the European Court of Human Rights since 1992, especially in cases against Turkey and Russia. He has acted as a consultant and expert for the United Nations, the Council of Europe, the Organization for Security and Cooperation in Europe, the European Union, and the UK government, the United Kingdom government. Bill has more than 150 publications, including monographs, edited collections, chapters, and articles. His first monograph, The Degradation of the International Legal Order, the Rehabilitation of Law, and the Possibility of Politics, has been translated into Russian. His second monograph is Law, Rights, and Ideology in Russia, Landmarks in the Destiny of a Great Power. In 2017, Bill was awarded a fellowship of the Academy of Social Sciences for his work on Russia. Bill will provide a background on the 3 regional systems and then focus on the European system. Walter Antion was born in San Jose, Costa Rica in 1932. He studied law at the University of Costa Rica with postgraduate degrees in Rome and Buenos Aires. He has been a law professor for 62 years at various universities in Costa Rica and other countries. Walter has given courses and conferences in many countries in Latin America and Europe, and has worked for justice in Costa Rica and Nicaragua. He is the author and co-author of over a dozen books and more than 100 journal and newspaper articles. Walter has fought on different fronts for the realization of the fundamental rights of marginalized people. Walter will discuss the Inter-American system. Stanislas A. Ajon is a Chevening scholar and past president of the FACO Lawyers Association. He is also vice president of the African Bar Association with responsibility for Central African subregion. The holder of an LLM in human rights from the University of Aberdeen in Scotland, Stanislas is an international human rights lawyer called to the Cameroon Bar in 1999. With more than 2 decades of experience in Cameroon and Africa, Stanislas has handled electoral disputes before the Supreme Court in Cameroon and 3 communications before the African Commission against the Federal Republic of Nigeria and the Republic of Cameroon. He facilitated 2 legal clinics on rights to employment and to education in Africa under the auspices of the Inter-Rights Group in Kenya in 2012 and 2013. From 2010 to 2013, Stanislas was Lecturer of Human Rights and Development at the Pan-African Institute of Development in West Africa in Cameroon and taught both at the graduate and undergraduate levels. He has also published about the right to self-determination. Stanislas is the founder and senior partner of a security law firm in Cameroon. Stanislas will discuss the African system. And now, Bill, take it away. The stage is yours.
Thank you, Gail, and thanks very much to Marjorie Cohen and to the People's Academy for the invitation to come here today. It's a great honor, and particularly to be with 2 such distinguished colleagues. So I'm going to speak for 15 minutes now to introduce the topic. And this, I should say, is a topic I've been teaching every year for 20 years. So I hope not to be repeating myself word for word. Where I start is with something really disgraceful, which emanates from North America, not from Canada, I hasten to add, but from the United States. And this is actually not a bad textbook on international human rights by the American political scientist David Forsyth, and it's now in its 4th edition. And at the end of each chapter, he has useful questions for the students using the book so they can test themselves on what they have learned. And when I got the 1st edition quite a lot of years ago, I was really shocked by the question which Forsyth gives at the end of his chapter on regional systems. It's 2 sentences. I will read it to you slowly, and hopefully you will be as shocked as me. It goes, what explains the quality of regional protection of human rights in Europe compared with the Western Hemisphere and Africa? Say it again. What explains the quality of regional protection of human rights in Europe compared with the Western Hemisphere and Africa? Question mark. Is it likely that the latter 2 regions will evolve so as to duplicate the European record? I hope you're as shocked as I am. I think that is, I mean, it's racist in a number of ways, and this idea of, so I asked my students, what can we mean by quality in a regional human rights protection system? That's a difficult question to answer. And if you're asking about how big the system is, or how many applications are received, or how many judgments there are, I'm not sure that tells you anything about quality, really, because what you want to know is, has anything changed as a result? So I'm going to be talking to you in a short while about the European system, which is now in very, very deep crisis for obvious reasons. And the second word, which absolutely gives me the creeps, is evolve. Because when you see evolution in a school textbook, on the left-hand side, you have little bacteria and single-celled organisms. And then as you progress in the right-hand direction, you come to some kind of sea creatures, then to amphibians who come onto the land, and then to dinosaurs. And then at the right-hand end, in all its glory, is a man, usually. So this is the peak of evolution, is Homo sapiens, or the male version anyway. And what a terrible idea that somehow the world, Africa and the Americas need to evolve so as to become as quality as the Europeans. And the third word I find absolutely shocking is duplicate. Because on practically every occasion when there has been an attempt to duplicate from one country or one region to another, it's a disaster. And I do have a chapter I can send anyone who's interested called Rejected Organs, which is all about how duplication of law from one continent to another. So I hope I've shocked you. And as I say, this comes from North America. And of course, the United States of America is the country which does not accept international human rights by and large. So, and it's now the United States. I say there are now three geriatrics, Mr. Putin, Mr. Trump, and Mr. Netanyahu, who are doing their level best to dig the grave for a rules-based international order. So that is the context in which we are now speaking. Gail is lucky enough to come from a country which is still free, although subject to extreme bullying by Donald Trump. So what do I have to say about the three systems? So what I'm saying is, you have to take each one in its historical context. This is why it is absolute nonsense to talk about evolution or duplication, because each regional system can only be understood in its own historical context. And actually, the very first document was in the Americas, and that was in 1948, the American Declaration of the Rights and Duties of Man, of the Organization of American States. And the Organization of American States still has a building in Washington, D.C., which is enemy territory, by the way. In the heart of the United States government, there is something which is absolutely not recognized by the United States, but there it is. Organization of American States. But for reasons I will come on to in a minute, we don't have the development of the inter-American system until much later. And why was that? That's because right up until the 1980s, Latin America was subject to military dictatorships sponsored and supported by the United States of America. And that's why, as Walter will tell us, the inter-American system really came into its own only from the 1980s. And of course, as Stanislas will tell us, what was Africa right up until actually the 1960s, 70s? It was colonial possessions of European powers. A book which I'm not going to talk about at length, but I like very much, is the book The Black Man's Burden, The Curse of the Nation State in Africa. And the fantastic damage done to the continent of Africa by the European powers that carved it up from the 19th century onwards in particular. So back to Europe. I'm speaking to you from the city of Colchester in England. And England, of course, was the center of the British Empire, on which the blood never dried, in the apt words of one of the historians of the British Empire. So what's going on? And in Europe, we had the Council of Europe in 1949, founded, as I will relate in a bit, by Winston Churchill, no less, and the European Convention on Human Rights in 1950. What were they? Well, I'll talk more in detail in a minute, but it has been properly said that the Council of Europe and the Convention were the ideological counterpart of NATO, because the Council of Europe was founded in the context of the Cold War. And so on one side, the USSR and its allies, they had the Warsaw Pact. That was their military alliance. The military alliance of the Western states was NATO, North Atlantic Treaty Organization, of which we hear quite a lot again, still today. So what was the Council of Europe for? It was the members of NATO, so 10 countries at the beginning, Western European states, seeking to demonstrate their superiority in terms of human rights to the Soviet bloc. Of course, things have changed and things have developed since then, as I will relate. But that was the beginning of the European system. European system, as you will hear from me, has undergone remarkable changes, particularly with the collapse of the Soviet Union in 1991. But you cannot understand, in my opinion, what the Council of Europe and the European Convention on Human Rights are outside of that historical context of the Cold War and the collapse of the Soviet Union, and now the horrendous crisis of the European system. So the second regional system we're going to be looking at, and I already mentioned something, is the Inter-American system, based in Costa Rica, where Walter is speaking to you from, known as the Switzerland of Latin America. It doesn't have armed forces, and it was a natural place for the Inter-American system on human rights to be based. The one country which has had nothing to do with it is the United States of America, and Cuba for other reasons, which Walter may tell us about. Otherwise, though, it is a big and very lively system, and in many ways, its case law and jurisprudence are superior to that of the European Court. They're tackling much bigger issues, and whereas the European Court, by and large, tells countries that they have violated human rights and orders them to pay some money, it's only in a few cases that detailed instructions are given to the state concerned as to how human rights violations are to be prevented in future. And the Inter-American Court on Human Rights, on the contrary, gives detailed judgments with detailed requirements for states as to what they have to do. And I'm happy to tell you that the European Court of Human Rights increasingly is learning from the Inter-American Court of Human Rights. So we will expand on those issues. In Africa, I'm very happy to tell you that although my work as a human rights practitioner has been mainly in the European Court, I have been involved in an important case, the ECOWAS. ECOWAS is the Economic Community of West African States, including Cameroon. And ECOWAS has a court, including a human rights court. And I was involved in taking a case against Gambia about the murder of the journalist Dada Haidara. And that court is based in Abuja, the capital of Nigeria. So that's in addition to what Stanislas is going to be telling you about, which is the African Commission based in Gambia, and the African Court of Human Rights, which is now operating in Arusha. So that system could not have come about until the huge anti-colonial struggles in Africa. So Ghana, the first African, sub-Saharan African colony of Britain to become independent, and actually the Ashanti were never defeated by the British, actually. So there are many histories, but the rapacious behavior of European states in Africa has meant that it was only really after the beginning of the 1990s that the system began to come into its own. So I hope that gives you a little bit of food for thought as an introduction. And I don't think I've stolen any of the thunder from Walter or from Stanislas, who will have much more to tell you about their respective systems. But thank you for your attention so far. And of course, if any questions arise from what I've just been saying, I'll be extremely happy to try to answer. I think that's my 15 minutes, Gail.
Now you could go ahead, Bill, and talk about the European system.
Thank you very much.
Thank you.
As I say, I'm speaking to you from the United Kingdom, more specifically from England. And of course, we have 4 nations in the United Kingdom. So what I will say for nothing to begin with is that in my lifetime, there will be the reunification of Ireland, which was the subject of some of the most bloody British colonialism over the centuries. Scotland, there's a strong independence movement. I think it will become independent, though not in my lifetime. And in Wales, where the Welsh language is strong, and they were brutally suppressed by England, for centuries, they are getting itchy feet. However, I want to start by talking a little bit about the French Revolution. Why will I want to do that? Specifically, 1789. That was the year of the Déclaration des droits de l'homme ou du citoyen. So the Declaration of Human Rights and of the Citizen in 1789, put together by French revolutionaries who didn't expect to be living more than a year or two. And of course, putting up a monument would have done them no good. But it's much more difficult to kill ideas. And actually, the Declaration of Human Rights and of the Citizen is still part of the French Constitution to this day, and is actually, for reasons I will explain, when you look at the French Declaration on Human Rights of 1789 and the European Convention on Human Rights of 1950, they are almost identical, word for word. And is that surprising? I personally say that when Britain finally incorporated the European Convention into its domestic law, which wasn't until the year 2000, for reasons I will explain, Britain finally came into the 18th century. Of course, we still have feudalism in Britain, so I'm not too sure about that. But so that's how it looks. This is actually rather significant also for the United States of America, because the Declaration on Rights of Man and the Citizen was condemned by the intellectual father of British conservatism, Edmund Burke, an Irishman, but he was the inspiration for conservatism in Britain right down to the present day. And he wrote a denunciation of the French Declaration on Rights of Man, saying that it was intellectual terrorism and a bomb which would blow up all institutions. The answer to Edmund Burke came from somebody my American listeners will have heard of, Tom Paine. And Tom Paine wrote a tremendous book called The Rights of Man in answer to Edmund Burke. And Thomas Paine, in his book The Rights of Man, condemned the British monarchy and aristocracy. And actually, they're still there. So Tom Paine's words actually read as if they are contemporary. Tom Paine also wrote a book called Common Sense that was one of the main inspirations of the American Revolution against Britain. And so going back through the centuries, what one can say is that both Britain and America, which has followed Britain in many ways in terms of law, are very allergic to rights of man and human rights. Neither Britain nor the United States like them at all and condemn them. So how did the change come about? And the change came about in the Second World War. So in the Second World War, of course, Britain, the United States, and the Soviet Union were allies against Nazi Germany. Winston Churchill, as I'm sure everybody knows, although he was an alcoholic and a very nasty imperialist, he became the Prime Minister of the United Kingdom. And as early as 1943, Winston Churchill he made a radio broadcast saying that maybe a result of victory against the Nazis should be a Council of Europe. So he invented the phrase. And actually, what happened at the end of the Second World War in Britain was a disaster for Winston Churchill. In 1945, Britain, having won with the Soviet Union and the United States against Nazi Germany, and Churchill thought he was the great hero, and there was a landslide victory of the Labour Party in 1945. Churchill lost power. And you can imagine, this was absolutely traumatic for him. I'm not going to say that the Labour Party, which took power in 1945, led by Clement Attlee, was a revolutionary government, far from it. They were very enthusiastic founders of NATO, North Atlantic Treaty Organization. They were very strong supporters of Israel in what Israel was doing to the Palestinians. And it was in many ways an imperialist government. However, it did see the beginning of the welfare state and the National Health Service, which the present Labour government is doing everything it can to destroy so that we can have the same as America. But that's a slightly different topic. So here's Churchill at the end of the Second World War, and he suffered a shocking defeat. What did Churchill do? Actually, in 1946, Churchill made his famous speech, I think it was in the United States, where he coined the phrase the Iron Curtain, which has come down across Europe. So USSR, Britain and the United States, which had been allies against Nazi Germany, now it was the beginning of the Cold War of the West against the Soviet Union. And Churchill, having coined the phrase of the Iron Curtain, he decided that there had to be a unity on ideological issues between the Western European countries, 10 of them at that time. There's a very good book which came out not very long ago called The Conservative Human Rights Revolution. Excellent book. And on the front cover is Winston Churchill. Because maybe all of you already know, but many people don't know, my students are always surprised to hear that Winston Churchill was the founder of the Council of Europe and of the European Convention on Human Rights. It was a conservative project. And what did Winston Churchill hope to achieve? And he had two main objectives. One was solidarity against the Soviet Union and its allies in the Cold War. Secondly, he wanted to prevent the possibility of Labour and socialism, as he saw it, ever winning again in the United Kingdom. So that was a very clear motivation, two very clear motivations of Winston Churchill. And in 1948, there was, so he's still out of power, Labour is in power, but Churchill was a motivation for a Congress of Europe with hundreds of delegates, and they met. And in 1949, 5th of May, the Council of Europe was founded. And by the way, the Council of Europe today is still 46 states, 675 million people, so not insignificant. And that was its beginning. And I'll tell you which were the 10 states at the beginning of it. They were Belgium, Denmark, France, Ireland, Italy, Luxembourg, Netherlands, Norway, Sweden, and the United Kingdom. And 1951, Churchill was back in power, defeated the Labour Party, and the Labour Party has only been in power now it's the second time since then. So mainly we've had conservative governments in Britain. And 1953, the European Convention on Human Rights came into force. And it was the first time in the world that you had a treaty-based international system with a court with compulsory jurisdiction over its members. First time ever in human history. that states which were members of the Council of Europe were obliged to accept the jurisdiction of the European Court of Human Rights. And that's a treaty obligation. The court began its work in 1959, and the very first case to be heard by the European Court of Human Rights was in 1960, the case of Lawless against the Republic of Ireland. Of course, I should mention that the Republic of Ireland only became independent after a very bloody war of independence against the entire British Empire, which they won. And it started in 1916 with the siege of the post office in Dublin, been going on for centuries prior to that. And the British Empire had to capitulate. And Ireland has been an independent republic ever since then. So there was the Republic of Ireland. By the way, when at the end of the Second World War, when the British Empire gradually fell to pieces, the idea was it would be replaced by the British Commonwealth of Nations, which still exists. Ireland has never been a member of it for obvious reasons. So that was the first case in 1960. Britain ratified the European Convention on Human Rights in 1953. As I will come on to the reason in a minute, it didn't become part of our law until the year 2000. And we did not allow complaints to be made against us at the European Court of Human Rights until 1966. So from 1953, when we ratified it, until 1966, it was not possible to bring cases against the United Kingdom. Why was that? 2 words, British Empire. Because Britain was petrified the cases would be brought against it in relation to its colonial behavior. And Britain was fighting very bloody colonial wars in Malaysia after the Second World War, in Yemen, right up until 1967, a very bloody war Britain was fighting. Genocide Britain was committing in Kenya. And so Britain was extremely worried that if cases could be brought against it, they would relate to Britain's colonial activities. And this turned out to be the case. So the first 3 cases against the United Kingdom at the European Court of Human Rights were interstate cases, because most cases at the European Court of Human Rights are individual victims or groups of people who are victims of human rights violations, but also interstate cases, one state against another. So more or less the very first such case was Greece against the United Kingdom, and Greece against the United Kingdom related to Britain's activities in Cyprus. And Cyprus, people may know, it's an island in the Mediterranean. Presently, it's divided between independent Cyprus and northern Cyprus, which is militarily controlled by Turkey. And Cyprus was a British colony. And in fact, there are 2 very large British bases in Cyprus, which are British territory within Cyprus to this day, from which help is given to Israel in its genocide against the Palestinians. Still going on. So during that period of the 50s and 60s, there was a very bloody war, colonial war, within Cyprus. And there was a movement called AOKA, which wanted to unite with Greece, so Greek speakers in Cyprus. led by Archbishop Makarios, and their military wing was led by Colonel Grivas. And actually, the British fought them with extreme brutality. And so, what Greece was doing, taking a case against the United Kingdom, was about the atrocities committed by British troops. Now, that case was settled on the basis that Britain agreed to not to Cyprus joining Greece, but to Cyprus becoming independent, but without those two large territories which Britain kept. Very similar to Guantanamo in Cuba, by the way. Very similar situation. Second case, East African Asians. And this was to do with the British in East Africa handing over power on independence in Uganda to Idi Amin Dada. And Idi Amin Dada, to whom the British handed power, decided on a policy of Africanization. What did this mean? In West Africa, and to this day in South Africa, there are very large populations from India. And they were brought from India by the British to Africa to act as civil servants, tradesmen, lawyers, and for several generations. So Idi Amin Dada decided Africa for the Africans, they must leave. So these unfortunate people had passports of the United Kingdom and colonies, same passports that people had in the Falkland or Malvinas Islands and in Hong Kong. It's a wonderful passport because it does not give you the right to live in the United Kingdom. So it's called Passport of the United Kingdom and Colonies. You cannot live in the United Kingdom. And to make matters worse, a Labour government passed a law called the Commonwealth Immigration Act, saying that if you have a white skin, you're very welcome to come to Britain. So if you come from Canada, Gail, which became, how did it become white? Through, of course, nasty things happening to the indigenous population. Australia, how did that become a white dominion? New Zealand, how did that become a white dominion? Anyway, white people, very welcome. If you have a black or brown skin, go to hell. You can't come. So it was an absolutely horrific piece of racist legislation. And luckily, the East African nations as a group got some good lawyers. And a case was brought against the United Kingdom at the European Court of Human Rights. And the East African nations complained of inhuman and degrading treatment, because they'd been given these useless passports, not giving them the right to live in UK, having been thrown out, and there was nothing for them in India, and discrimination. And to the horror of the United Kingdom, they won. And if you come to London today, it's one of the most diverse cities in the world. I absolutely love it. And the Tories absolutely hate it. And we have 20% Muslim population in London now. And actually, a very big population of people who came or whose ancestors came from East Africa. And nearly every petrol station and small shop in London now is owned and run by people who came from East Africa with not a penny, but having won their case at the European Court of Human Rights. And the third case is a case which relates to a country I already talked a bit about, Ireland. Because for centuries, England has been repressing Ireland, one massacre after another. And in 1969, the so-called Troubles began, which was a civil war in Ireland. There was only peace in Northern Ireland, only peace in 1998. And British troops were sent into Northern Ireland, and there was a campaign of resistance by the Irish Republican Army, which received a huge amount of money from the big Irish population in the United States. How come there's so many Irish in the United States? Because in the 19th century, there was the Great Famine, when the population of Ireland went down from 8,000 to 4,000, and Britain stood aside while Irish people died of starvation or went to the United States. Population of the whole of the island is still only 5 million, by the way. So Britain has a history there. And what Britain did from 1969 was to arrest very large numbers of people and hold them in detention camps, concentration camps, without charging them or putting them on trial, because they were suspected of involvement in Irish republicanism. Very few of them were ever charged with anything. However, what the British were doing in these detention camps was torture. And so the case that was brought by the Republic of Ireland against the United Kingdom, so-called case of the hooded men, that was the case of people detained by Britain who were subjected to the following torture. They had to stand against the wall in a stressed position with a hood over their head, with very loud noise in the background, with minimum food or drink. That is psychological torture, which we franchised then to South Africa and to Israel. It's very effective psychological torture. Doesn't involve electric shocks. It doesn't involve beating. But by and large, it works in a not very long period of time. And this case went to the then European Commission on Human Rights, and the European Commission on Human Rights said it was torture. And exactly, thank you, Stephen Lyons. You're correct. And the case then went to the European Court of Human Rights, which fudged the issue and said this was not torture but inhuman and degrading treatment. But it's absolutely clear now that what was going on was torture, and this was in 1978. And by the way, Britain, in order to get the result it wanted at the European Court, hid more than 40,000 relevant documents, which have now been found, and the Republic of Ireland went back to the court not very long ago, saying that had the cases, had the information been given to the court and not hidden by Britain, it would have been a different result. So, as I was saying, the civil war in Northern Ireland went on until 1998, the Good Friday Agreement. And to this day, of course, we now have the situation where the ruling party in Northern Ireland is Sinn Féin, which was banned by Britain from being broadcast or whatever. And it's now a significant force in the Republic of Ireland too. So actually, because of the fact that Britain didn't make the convention part of its law until 2000 now, I talk about myself briefly. I became a barrister in 1974, and I was taking a lot of criminal cases, family cases, civil actions against the police, up until I became an academic in 1990. I was not allowed to refer to the European Convention in English courts because even though Britain had ratified it in 1953, it was not part of British law. So if you were a victim of violation of human rights by the United Kingdom, you had to go all the way through the British courts, taking you 5 years or so at least. Then you could take a case to Strasbourg against the United Kingdom. And indeed, most of the leading cases in the jurisprudence of the European Court of Human Rights in its first decade or so were cases against the United Kingdom. Surprise, surprise. And there were, as a matter of fact, even significant changes in the law as a result of cases brought against the United Kingdom. What happened in 1991, that was the collapse of the Soviet Union. 1989, down came the Berlin Wall. And so in the place of the Soviet Union, you had independent Ukraine, which had been a full member of the United Nations in 1945, by the way, because Ukraine, contrary to what Putin likes to tell us, was a union republic of the USSR with its own seat in the General Assembly of the United Nations, along with Belarus. So Putin has a fit if you remind him of that. So Ukraine and the other union republics became independent, and there was Russia. And Russia was a territorial empire. Britain was a maritime empire. So the British colonies were in Africa, Asia, Latin America. The Russian Empire was territorial, and it included the Caucasus, Central Asia, and right out to the other side of China, to the other side of Japan. So a huge empire. To this day, there are ethnic republics of the Russian Federation, including Chechnya, for example, where very few ethnic Russians live. And so what was happening from 1991 was Russia, the Russian Federation, was an independent state. And for 10 years, Boris Yeltsin was the first elected president. And Boris Yeltsin was very keen on showing how different the new Russia was from the Soviet Union. And so 1991, the Soviet Union collapsed. 1996, Russia joined the Council of Europe, to everyone's astonishment, and was allowed to join the Council of Europe, even though there was a horrific war going on in the colonial war of Russia in Chechnya. Germany was particularly keen on Russia being able to join. And within Russia itself, even though they would be obliged to ratify the European Convention on Human Rights and be subject to the European Court of Human Rights, the thinking in Russia was, with the collapse of the Soviet Union, there were 25 million Russians living outside Russia, many of them in Europe and in Western Europe. So there are huge Russian populations to this day in Latvia, in Estonia. There's a whole chunk of Russia, Kaliningrad, in the middle of the European Union. And so 25 million Russians in the wrong place, as it were. And so the thinking in Russia was, okay, we'll probably lose quite a few cases, but it won't cost us very much to lose them, actually, because the European Court of Human Rights rarely orders more than 30,000 euros compensation. And this will give us levers for looking after the ethnic Russians outside Russia. So in 1998, Russia ratified the European Convention on Human Rights. In 1999, Putin, who you might have heard of, became the Prime Minister of Russia and started the Second Chechen War, in a colonial war in which a huge number of people died. And at the stroke of midnight of 1999-2000, Boris Yeltsin resigned. Putin became the acting president of the Russian Federation, and Putin has been in power ever since. So when he says to Ukraine, oh, you've got to have elections, say, come on, please, Mr. Putin. When was there last a real election in Russia? He's been in power ever since. So, Second Chechen War, Russia was by then a member of the European Convention on Human Rights. And I had first gone to Russia in 1983, fallen in love with the Russian language, traveled there a great deal, had been involved in teaching European human rights in Russia. And in 2002, I got €1 million from the European Commission to set up the European Human Rights Advocacy Center, which still exists, in partnership with the leading Russian human rights organization, Memorial, which is now banned in Russia. They're in exile. Like everything else in Russia, they are condemned as foreign agents. But at that time, we set up a project with Russian lawyers and British lawyers. Judith Murkison, I will answer your question later if I may, please. So there was our project. And during the period from 2002-2003, we took hundreds of cases against Russia at the European Court of Human Rights, initially in relation to Chechnya and the bloody Russian colonial war there, but on many issues, including environmental cases and many other sorts of cases. And at that time, the Constitutional Court of the Russian Federation, which was modeled on the German Federal Constitutional Court, they recognized the European Court of Human Rights as being superior to them. And many, many cases, so I represented people in quite a lot of them. The experience for this, I should add, came from 1992, from a decade earlier, when I became active with the Kurdish Human Rights Project and was involved in taking hundreds of cases against Turkey on behalf of Kurds. This suits me very well because my scholarly interest as a professor is in the right of peoples to self-determination. Both the Kurds against Turkey and the Chechens against Russia, classic self-determination struggles. And so I started taking cases against Turkey in 1993. We got our judgments, because it takes a long time, late 90s, 2000s. And that was then the experience and the colleagues I brought together for the project concerning Russia. And so we had very good relations, as a matter of fact, with the Constitutional Court. And if anyone's interested, I've written book chapters on the 20 years of relationship between the Russian Constitutional Court and the European Court of Human Rights. What then happened? Of course, 2014, Russia illegally annexed Crimea, which was part of sovereign Ukraine, and began to arm the separatists in the east of Ukraine, what we call Donbass, with very little support from local people. And by the way, I've been working in Crimea myself from the 1990s, and Russia had, by treaty agreement with Ukraine, 25,000 troops in Sevastopol, which was leased to Russia by Ukraine. So in 2014, Russia seized Ukraine. Now, there were some sanctions, and for a period of time, the Russian delegation, because the way the Council of Europe works is that you have a Council of Foreign Ministers of the member states, that's the executive. Then there's a parliamentary assembly, which is parliamentarians from all of the, was 47, now 46 member states. And they, amongst other things, elect the judges to the European Court of Human Rights. So the Russian delegation were, for a period of time, deprived of their voting rights because of what had happened. However, prior to 2002, a deal was done between the Council of Europe and Russia. And Russia got back its voting rights, and it hadn't been paying its money to the Council of Europe. It was one of the biggest payers because it's by size of population. They started paying again. That was not very long before 2022, which is when Vladimir Putin started the all-out aggression, the all-out invasion of Ukraine. And it won't surprise any of you to hear that Russia was expelled from the Council of Europe. It is now outside of it. There's still a backlog of 18,000 cases still being heard, existing cases against Russia. So there are still judgments. But the Russian people have been deprived of the opportunity to take their cases to the European Court of Human Rights. That's gone for them. And it's a disaster all round. What's happened with Britain is that, as I told you, the Tories historically, the Conservatives, have hated the idea of a European Court of Human Rights. They've forgotten that it was Churchill who invented it. And so the Conservatives are now the Trumpists, they're called the Reform Party, and Nigel Farage in Britain. One of the first things they want to do is to take Britain out of the European Convention of Human Rights and the Council of Europe. My last case against Russia was, we got a result in 2021. And you might have heard of Alexander Litvinenko, who was a member of the Secret Service in Russia, the same rank as Putin, and the same rank as the person who murdered him. He was murdered in London with radioactive polonium poison in 2006. And absolutely no question that it was done on the orders of Putin himself. And this was after he'd become a British citizen. He died in agony. And I represented his widow, Marina, at the European Court of Human Rights. Now, a fast case at Strasbourg is 5 years. A slow case is much more. And I finally got a judgment on behalf of Marina in 2021 that Russia had murdered her husband and ordered a payment to her, which she will never see. What she wanted was the court finding, and it has to be proved beyond reasonable doubt, that it was on Putin's orders that her husband was murdered with radioactive poison. Not the only one, by the way. There have been quite a few of these. So I think, Gail, am I at the end of my 40 minutes? You're muted. Gail?
There I
Yeah.
am. Thank you very much, Bill.
Am I at the end of my 40 minutes?
I beg your pardon. Yes, you are.
Good.
Thank you for being so good about your time. But thank you very much for that enormously complex history of the European Convention on Human Rights, and particularly the involvement of cases before the European Court of Rights having to do with the with Ireland and with Chechnya. And I'm sure that people in the question period will want to ask whether the outcomes of those cases had any beneficial.
That is such a good question. That's such a good point.
And next, we're going to go to Walter. Just before you start, Walter, I want to remind people that Walter's going to speak in Spanish, so if you need a translation, go to the interpretation button and choose the translation into English. So with that, Walter, please go ahead. Thank you.
Muy buenos días.
Good
Espero que
morning.
se escuche bien, con
I
claridad.
hope you can
voz.
hear me well, that you can hear my voice.
Espero que los intérpretes
I
cumplan su difícil
hope the
papel
interpreters can
de
perform
traducir.
their difficult role of translating this.
Yo voy a hablar
I'll speak
de el sistema de derechos humanos
about the human rights
de
system,
América Latina.
the Latin American human rights system.
Los derechos humanos son un
The human rights
antiguo problema de la humanidad.
are an ancient problem in humanity.
Hemos luchado por ellos
We have struggled for them
durante siglos,
for centuries,
aún sin usar el nombre de derechos humanos.
even without or before using the human rights name.
Se puede decir que es a partir de
We
la
can
Revolución
say that
Francesa
it was with the French
en que
Revolution
hablamos de los
when
derechos
we
del hombre
started
y del
about
ciudadano
man and
primera vez.
citizens' right for the first time.
Esto produjo
This created
que las constituciones
or
políticas
produced that the political
de
constitutions
nuestros países latinoamericanos
or Latin American countries
incluyeran una
include
sección
a section
sobre
about
derechos civiles y políticos.
civil rights, political rights.
El problema es que eso
The problem
no
is that
fue suficiente
it wasn't enough
para que los derechos de las personas
for
fueran
human
respetadas
rights to be
en
respected
nuestros países.
in our countries.
Sabemos que en América Latina
We know that in
el
Latin America,
caudillismo y la inestabilidad de los gobiernos
the
se tradujeron
instability in the
en
government were
una
translated
endémica fragilidad
in an
institucional
endemic fragility, institutional
con la consiguiente
fragility,
efemeridad de las constituciones
with the
y el sometimiento
consequent
de los tribunales de justicia
dying of the
al
constitutions
poder político.
and the justice at the tribunals
El problema
from the political
estaba
side.
en el paradigma vigente sobre la organización
The
judicial
problem was in the
en
current
los siglos
paradigm
XIX
in the
y
judicial
XX.
organizations in the 19th and 20th centuries.
Según este paradigma,
So
los
according to this
jueces
paradigm,
del Estado
the
están
state
colocados
judges
en una pirámide
are put
jerárquica.
in a hierarchical pyramid.
La Corte Superior
So
de Justicia
the
es
superior
la
court,
cabeza del sistema
the
judicial,
superior justice court, is
pero
the head of
el
the judicial
Parlamento
system,
y el Poder
but the
Ejecutivo,
parliament and
o
the
uno de ellos, domina la
executive
justicia
power
porque
dominate
selecciona y
justice
controla a los jueces de la Corte.
because they select and control the court judges.
Este paradigma también
This
fue
paradigm was
vigente
also
en la Europa de la primera parte del siglo XX,
working in the first part of
pero
the
la
20th century
experiencia
Europe.
del fascismo,
But the experience of
el fascismo
fascism,
hitleriano y el fascismo
Hitler's
de Mussolini,
fascism, Mussolini's fascism,
mostraron
showed
la enorme
showed
debilidad
the
de un
huge
sistema judicial
showed the huge weakness of
organizado
a
bajo
judicial
este paradigma.
system organized under this paradigm.
Por eso, al terminar la Segunda Guerra Mundial,
Hence, after finishing the World War
los
II,
juristas europeos
the
se
experts
ocuparon
in law from Europe
de cambiar el paradigma
were in charge of
con el
changing the
objeto de
paradigm
fortalecer
with the
la
goal
justicia.
or with the objective of strengthening the justice.
Esto, sin embargo,
However,
no fue así
this
en América Latina.
wasn't
Y vamos a explicar
like that
después
in Latin America, and then
por qué
we'll
razones.
explain why it was like that.
El final de la Segunda Guerra Mundial también
The end of
coincide con la
World
fundación
War II
de las Naciones
also
Unidas y la
coincided
Declaración
with the
de los Derechos Humanos
Human Rights
de
Declaration
1948.
of 1948, and also with the
Esta
UN.
declaración
This declaration
produjo en el mundo
produced in the world
un rejuvenecimiento por el entusiasmo, el
a
optimismo
rejuvenation
acerca
for the
de la
optimism
solución de los grandes
towards
problemas.
the solution of the big problems.
Sin embargo,
However,
en lo que a América Latina se refiere,
in respect
realidad,
to Latin America, actually
hubo que esperar
we had to wait
a la celebración
for the
de la
celebration
Convención de los
of
Derechos
the Human Rights
Humanos
Convention,
del llamado Pacto de San José,
the so-called San Jose
en
Treaty,
donde
or Pacto de San Jose in
América Latina
Spanish, where Latin America
contó con un
counted
cuerpo de
with
normas
a set of
obligatorias
rules of
en la materia de los
mandatory
derechos humanos.
rules in human rights.
Este cuerpo de normas obligatorias
This body of rules, of mandatory
viene a
rules,
ser operativizado
come into
por
operation
dos órganos principales
thanks to
que
two
son
main
la
organisms,
Comisión
which are
Interamericana de los Derechos Humanos y
the
la Corte
Inter-American Human
Interamericana
Rights
de
Commission
los Derechos Humanos.
and the Human Rights Inter-American Court.
Estos organismos estaban llamados a suplir
These
la deficiencia
organisms
de la tutela
were
de los derechos
called
en
to
nuestros países.
cover the deficiency that
El
human rights
problema
had in our
fundamental
countries.
de nuestros países era
The main problem in our
la
countries
tradicional
was the
sumisión
traditional
de la justicia
submission to
al
justice,
poder político.
of justice, like the submission of justice to the political
Las
power.
constituciones de América Latina
Uh,
consagraban una
constitutions
larga lista
in Latin
de derechos
America
fundamentales.
listed or had a long list of fundamental rights.
Una lista que incluía también los derechos
A
sociales
list that also
económicos
included
y
the
culturales.
social, economic, and cultural rights.
Sin embargo, sabemos que
However,
esta lista era
we know
inefectiva
that this list was not
precisamente porque
effective,
no había un órgano fuerte
precisely because
capaz
there was
de garantizar
a
esos derechos.
strong organism
Y en ese sentido,
that could guarantee those rights.
la Comisión y
In
la
that
Corte
sense,
Interamericana
The
se
Commission,
proyectaron
Inter-American Court,
como una solución
were
a
projected
este problema,
as a solution
¿verdad?,
to this
del
problem,
déficit de derechos para el ciudadano latinoamericano.
which was the
Claro, esto
rights
podía
deficit
variar de un
for the
país a
Latin
otro.
American citizen. So
Había
this
países en
could
donde era más
be different from
este,
from one country to
factible
the other. There were countries where
esperar
it
una
was
tutela de
more
los
possible
derechos,
to it
pero
was
América
possible
Latina
for some to
estuvo siempre
wait for the rights to be
bajo un
ruled, but
problema
Latin
constante
America
de
was
la dictadura.
always under the
La dictadura en
hard
América Latina fue una
dictatorship
solución
problem.
permanente.
So
Uno
dictatorship
estudia la
was a
historia de
permanent solution.
cualquiera de nuestros países,
You study the
salvo
story
muy
of
pocas
one
excepciones,
of
lo
each of our
normal
countries. The normal
sido
situation has
la
or had
presencia
been
constante
the
de
constant presence
regímenes dictatoriales.
of dictatorial regimes. Sorry if I'm pronouncing that.
Esto demandó muchos procesos
These
y también intervención
required
de
many processes
organismos
and
internacionales
also the intervention of
como
international
Naciones Unidas
organisms
o la
like the
Organización de los
UN
Estados Americanos,
or the
pero en
uh,
general el problema de los derechos
OEA,
humanos
but the main problem of the
era
human
un
rights
problema
with the human
agudo
rights was
en América
was an
Latina
acute
durante
problem,
muchos
a
años.
huge problem in Latin America for many years.
¿Qué son los órganos de la Convención Americana?
What are the
¿Qué
organisms
es
within the American Convention?
la Comisión Interamericana de Derechos Humanos?
What is
¿Y qué es
the
la Corte
Inter-American Commission
Interamericana
of Human Rights?
de Derechos
And what is
Humanos?
the Inter-American Human Rights Court or Court?
La Comisión Latinoamericana es un
The
órgano
Latin American
multifuncional
Commission is a
conformado por 7
multifunctional
miembros
organisms formed by 7
nombrados por la
members
Asamblea General de la Organización de
that
Naciones
are
Unidas,
named
entre
by
los candidatos
the
propuestos por los
organization
Estados miembros.
by the UN between the
El cometido
candidates that
principal
are
de la
proposed
Comisión
by the member states.
es el de
The
funcionar
main purpose of the commission
previo un minucioso debate entre
is
el
to
denunciante y el Estado denunciado,
promote an argument between
funcionar, digo,
the
como promotor
complaining
de la acción
and the
dirigida
state
a promover el proceso ante la Corte
to
a través del cual se
promote a
determinará
process
la responsabilidad
before
de
the
los
court
Estados
for which the
en
responsibility of the
acontecimientos
states
lesivos
will be
de los derechos de
be
los ciudadanos.
will be processed in regards to what has gone against the human
Por su
rights
parte,
of the person.
La Corte Interamericana de Derechos Humanos es un órgano de naturaleza
On the other hand,
jurisdiccional,
the Human
conformado
Rights
por 7 jueces
Organism is
nombrados por la
formed
Asamblea
by
General
7
de la
judges
Organización de
named
Naciones
by
Unidas
the
entre los
UN
candidatos que
and between
proporcionan
the
los Estados
candidates
miembros.
proposed by the member states.
Su cometido principal es
Their main purpose is to
tramitar
process
por vía
oral
oral
arguments and
los alegatos
evidence
y
of the
pruebas de las
parties
partes y
and to
sentenciar
rule on
sobre
human
las
rights violations
violaciones
that
a
have
los
been
derechos
committed
humanos
against the
cometidos por
members,
los
the
Estados
state
miembros,
members,
todo con
all
base en
based
el informe inicial
with
que le
initial
transmite la Comisión
report that is
Interamericana.
brought by the Inter-American Commission.
Estos
This
órganos
mechanisms
que están
that are
vigentes
current,
desde los años
that
70,
have been
80
working since
del
1970
siglo
and
pasado,
1980 of the last century,
son, sin embargo,
nevertheless are
claramente
not enough
insuficientes para
to be able to
responder
respond
a los
to
requerimientos
the needs
de los
of
derechos humanos
human rights of
de
the
los ciudadanos
citizens
en América
in
Latina.
Latin America.
Y es natural que
Naturally,
sean órganos
these bodies are not
insuficientes,
sufficient
porque
as natural, because
América
Latin
Latina es
America
un
is a
subcontinente
subcontinent
que
that
tiene
has
cerca de 500
more
millones
than
de habitantes
500 million
y sus requerimientos
people,
de
and their
justicia
needs
son
of
infinitos.
justice are infinite.
Son una
Is an
aspiración
aspiration
nunca
that is
satisfecha
never satisfied
desde hace
and
muchísimos
has
años.
taken many years.
De manera que, por
For
ejemplo, la
example,
Comisión Interamericana de
the
Derechos Humanos
Human Rights
recibe
Commission receives
miles
thousands
de
of
solicitudes de
requests for
intervención
intervention
por
on
las
these
violaciones.
violations.
Es una institución
It's an
claramente
institution that clearly
insuficiente.
is not enough.
Entre los centenares y miles de casos
Among
denunciados,
the hundreds and
la
thousands
Comisión
of
admite
cases,
una
the
parte muy
Commission
pequeña
takes
y
responsibility,
luego
part
de
in a
esa
very
puntual
small group of them,
instrucción
and in
probatoria
that
de
initial
los casos admitidos
initial probation period of the
con plena
admitted case
participación de los
with full
interesados,
participation
la
of the
Comisión
parties
selecciona
interested, and they
todavía
even
más
select
los que ofrecen
who they can
evidencia de
actually
delito
provide the evidence of a crime,
y entonces
and
invita
then
al
it invites
Estado
the state that has
infractor
committed the crime
a
to
cesar en los
evaluate
hechos
if these
delictivos
facts
y
and
reparar
make
los daños.
reparations and redress
Caso de que el
the
Estado
damage in
infractor no
the
acate
case that committed the
la
crime. Don't follow
invitación,
up the invitation
la
to
Comisión
deal with.
pasa el caso
The
a la
commission
Corte.
then passes this case to a court.
El trámite de la
How the
Comisión
commission then works in this,
desde su presentación
since
del
the
caso
beginning,
hasta la
the
remisión a
case
la
has been
Corte
presented
dura
to
un promedio de
then
6 años y
back
6
to be
meses.
put into a court. It can be from 6 months to 6
Por
years.
ejemplo, en el
For
año
example, in
2023,
2023,
de 2.692
of
peticiones
of
recibidas de
2,600
todos los países del continente
6,092 petitions received from all the countries,
pasaron al trámite ante
only
la Corte
34 of them went to
únicamente
court.
34.
They're actually then taken to court.
En
In
cuanto a la
terms
Corte
of the court, of the
Interamericana,
Inter-American Court,
tenemos que su primera sentencia
Walter,
es de
Walter, I wonder if you could pause for a moment to see if we can get the translation working again, because it isn't working right now. Thank you very much.
bueno.
And perhaps
Entonces
I
me
could,
gustaría que el traductor me informara acerca de la instrucción.
Can you hear me now? Can you hear me now?
I can hear I can hear you. Yes,
Sorry, my microphone went down.
I see. Okay, so are you ready to go again? All right, then, Walter, please continue because apparently the translator's microphone has been fixed.
No, no escucho bien. ¿Puedo continuar exponiendo?
Sí.
Muy bien. Estaba hablando
I was
acerca de la
saying,
Corte
Are we ready to go? Are you ready to go, the translator? Okay, so, sorry, we couldn't hear your translation again, but Walter, can you go ahead again?
Bueno, muy bien, muy bien.
yes, good.
No sé si yo estoy tratando de hablar muy
I'm
despacio.
trying to speak slowly.
Espero que eso sea
I hope
suficiente.
that is good enough.
Me refería entonces
So I was
al
talking
desempeño de la Corte misma.
about the performance of the court
Decía
itself.
que su primera sentencia
I was
es de
speaking of the first sentence
1989
happening in 1980.
y desde entonces la Corte
And
ha
since
dictado
then, the court
190 sentencias hasta la fecha de hoy.
has done issued 190 sentences since then.
A través de estas sentencias,
Through these
la
judgments,
Corte
the
ha
court
venido
has
imponiendo
imposed
cada vez con más claridad
with increasing clarity
criterios humanistas y democráticos,
democratic and humanist
tutelando
criteria,
una amplia gama de derechos
protecting a wide range
fundamentales
of
de las
fundamental
personas.
rights of people and individuals.
La duración promedio
Average
de un
length of our
caso
court
ante la
case
Corte
is
es
23
de
months.
23 meses. Como ustedes pueden ver,
As you can see,
la respuesta de la Comisión
the response of the
y la
Commission
respuesta de la Corte
and the response of
a
the
las
court
necesidades
to the
de
needs
protección de los derechos humanos
for
en
protections
América
of human
Latina
rights in Latin
son
America
respuestas muy
are responses
insuficientes.
that are not enough. They're not sufficient.
La cantidad de casos que se quedan
The amount of
por
cases
fuera de la
that are
tutela
left behind
de la Corte
under the
son
care of the court
muchísimos.
are many.
Y naturalmente que
And obviously,
las autoridades
the
de
authorities
la Comisión
of the
y de la
Commission
Corte
and of the
están
courts
conscientes
are aware
de esa insuficiencia
that about that lack,
y se esfuerzan por
and they work
tratar de reducir
to try
la
to
dificultad.
minimize this problem.
Y es en este punto en donde
And then it's
yo
from
quiero
this
mencionar
perspective I want to talk about
un instrumento
an
que ha
instrument
pensado
that has
la
been
Corte
thought
Interamericana
by the
con el objeto de
Inter-American Court
tratar de
with the
ayudar
objectives to try
a
to help
solucionar
and to
el
try to
problema.
solution this issue and this
Es un
problem.
aporte teórico
It's a
de la jurisprudencia de la
theoretical
Corte,
position from the
Se trata
jurisprudence of
de
the
la
court,
doctrina del control de convencionalidad,
and it is conceived
que ha
as the
provocado
control of
muchas reacciones diferentes
conventionality
en
that has
los juristas de todo el
created
mundo.
many different reactions
Según
from
esta
many different
doctrina,
lawyers in
los
the world.
órganos titulares
As
de
this
los poderes
doctrines,
públicos
the people in charge
tienen el
of the
deber
public
de aplicar
powers, they have
en forma directa las normas del derecho
right to apply
internacional
the
de los
norms
derechos humanos,
on the
así
doctrines
como las decisiones
and the decisions of the international
emitidas
human
por los
law,
órganos
as well all
jurisdiccionales
decisions are issued by
supranacionales.
the supranational jurisdictional bodies.
Dicho más claramente,
As according to this,
de
are
acuerdo
saying
con la
clearly,
mencionada doctrina
accordance with this
del
doctrine
control de
of the control
convencionalidad,
of conventionality,
es deber de toda
it is
autoridad
the right
pública,
of
en
every
particular
public
de los
authority,
jueces y de los
in
órganos
particular of
encargados de la
judges
administración de
and of the
justicia
bodies
en
responsible of
todos los niveles,
administration of justice at
ejercer
all
de
levels,
oficio
to
un
exercise
control
ex
de
officio
convencionalidad
a control of
entre, de
conventionality
una parte, toda
between
norma
one
jurídica
of the
interna
hand and all legal
y de otra
domestic norm,
parte, la Convención Americana sobre Derechos Humanos
including the
y
American
los
Convention on
demás
Human Rights
instrumentos
and all other
interamericanos
inter-American
de los
instruments
que el
to
Estado
which
es
the state
parte,
is party,
así como de la
also
interpretación
the
que de los
interpretation
mismos
of
ha
them
hecho la Corte misma,
that have been done by the
sea
Inter-American Court
por medio
itself
de su función
and is done through
contenciosa
its
o
advisory,
consultiva.
contentious advisory function.
Este deber
This duty,
que la
such duty,
Corte recarga sobre los funcionarios
that
públicos,
is within
sobre
the
todo
framework of the
sobre los
reciprocal
jueces,
competences to corresponding procedure regulations and
se
judges,
desenvuelve en el marco
is
de las
within the framework
respectivas competencias y regulaciones
of the
procesales
corresponding
que
procedure
corresponden
regulation
e implica la adopción de
that
medidas
implies the
en
adoption
dos
of measure in two
vertientes.
different aspects.
Uno,
The first one,
la supresión de las
the
normas y
suppression of
prácticas
norms and
de cualquier
practices of any
naturaleza
nature
que entrañan
that
violación
violate
a las
the
garantías
guarantees provided
previstas en la Convención
by the
o que
convention,
desconozca los
or that
derechos allí
disregard the
reconocidos,
rights recognized
obstaculicen
therein
su ejercicio.
or impede their
Y
exercise.
el otro nivel es
And the second
la
level is
expedición
the
de normas y el
issuance
desarrollo de
of
prácticas
norms and development of
conducentes
practices
a la efectiva
conducive
observancia
to the
de
effective
dichas
observance
garantías.
of these guarantees.
En síntesis, la jurisprudencia
In
de la Corte
summary, the
Interamericana
jurisprudence of the
nos permite
Inter-American Court
ofrecer
allows us to offer
el siguiente cuadro
the following
ilustrativo
illustrative
del
table
desarrollo
of the
progresivo
progressive
de la
development
doctrina del
of the
control
doctrine of
de convencionalidad.
conventionality control.
Hay una serie de
First,
sentencias de
and a
la Corte
series of
sucesivas
court
en el tiempo
that have
en
happened through
donde
time where we
la
have
doctrina del control de convencionalidad
the
se va
doctrine of convention
desarrollando
has been
paulatinamente.
developing through time.
Primero está el caso
First is the case
Almonacid Arellano contra
Almonacid
Chile.
versus
En
Chile.
ese caso,
In that
la
case,
Corte
the court
dispuso que el
said
Poder Judicial de cada estado
the judiciary
debe
power of each
realizar una
state
especie de control
has
de
to have some kind
convencionalidad.
of
O
conventionality
sea,
control. In other
los
words,
jueces
the
ordinarios
judges
del Estado
of the state,
tienen el deber
they have the
de
duty
controlar
to control
la infracción
the
de las normas
infraction of the norms
del tratado
of the treaty
de parte de los órganos
as part of the
del
bodies
Estado.
of the state.
Un segundo caso,
The second
el caso de
case,
los trabajadores del Congreso contra el Perú.
the dismissed
En
congressional
este caso,
workers versus
la
Peru.
Corte
In this case,
dijo de nuevo
said,
que los órganos del Poder Judicial
the organs of the
deben
judiciary
desarrollar
body must
no
develop
solo
not
un control
only
de constitucionalidad,
a control of
sino también un
constitutionality,
control de
but also
convencionalidad,
a conventionality
incluso
control,
de oficio, o sea,
even
sin que
ex
nadie
officio,
se los pida.
even if nobody asks for it.
Un tercer caso
A
fue
third case,
el caso Radilla Pacheco contra México.
Rodillo Pacheco
En este
versus
caso,
Mexico. In this case,
la Corte
the court
Interamericana dispuso que el
said
control
the
de
control of
convencionalidad
conventionality
no solo rige
applies
para
not
la propia
only
Convención
to the
Americana,
American
sino
Convention
también
itself,
para
but
la
also
interpretación
to the
que de la
interpretation
misma
of it
realiza la Corte.
made by the Inter-American Court.
Un cuarto caso es
A
el caso
fourth case
Cabrera García Montiel
is the case
contra
Cabrera García
México
Montiel
también.
versus
Aquí
Mexico. Also here,
la Corte dispuso que el
the
test de
court said
convencionalidad
the conventional
involucra a
test
jueces
involved judges
y órganos vinculados a la
but is
Administración de
linked to the
Justicia en
administration of
todos los
justice
niveles.
at all levels.
Por ejemplo,
For example,
el ministro de Justicia mismo, por ejemplo,
the
estaría,
Minister of Justice
de acuerdo con esta regla,
themselves, according
obligado
to
a
this
velar por la
rule, they have to
aplicación
be able to
de
pay
la
attention
convención
to the application of the
en el país.
convention in
El
the
quinto
country.
caso
The fifth
es
case
el caso
is the case of
Juan Gelman contra
Gelman
Uruguay.
versus Uruguay.
En este caso,
In this case,
la Corte ya dispone
the court
que
determined
toda autoridad
all
pública,
public
y
authority,
no solo el Poder Judicial,
are not only
debe asumir el
judicial
control
power,
de
must assume
convencionalidad.
control of conventionality.
Un sexto caso,
A sixth case
que es
that it
Atala
is
Rufo y Niñas
Atala
contra
Rufo
Chile,
and Girls versus Chile,
le dio ocasión a la Corte
and gives the occasion to the court
para imponer
to
la
determine
adecuación de las
the
interpretaciones judiciales y
education of the
administrativas
interpretation
y de las garantías judiciales
and the
a los
judicial
principios establecidos en la
to
jurisprudencia de la
necessarily
Corte
have the judicial
Interamericana.
interpretation and judicial guarantees to the principles established in the
Es-
jurisdiction of
significa
the
imponer
International
la
American Court.
presencia
It
de las
means to
normas
impose the presence
de la
of those
Convención
norms of the convention
en el desarrollo de la
in the
justicia
development
ordinaria
of
del
the
Estado.
common justice of the state.
Por último, tenemos el
And
caso
lastly,
también
we
de
have the
Hellman
case
contra Uruguay,
of Hellman
este caso
versus
en sede
Uruguay
de cumplimiento de la sentencia,
in the enforcement of C.
la Corte
Then the
estableció
court determines
que
that
existe la
there is an
obligación de
obligation
las autoridades del
on the part
Estado
of the state
de efectuar el
authorities
control de
to carry out their
convencionalidad
preventive
preventivo,
conventionality
teniendo en
control,
cuenta las interpretaciones
taking
de la
into
Corte
account the
Interamericana de Derechos
interpretation of
Humanos.
the Inter-American Court of Human Rights.
Este elenco de
This
sentencias de la
of
Corte nos
determinations by the
permite,
court
creo yo,
allows us, I
ver
think,
con mucha
allows us to
claridad
see clearly
el desarrollo del pensamiento
the
de la Corte
development
en
of the
relación
court in
con el
relation
llamado control de convencionalidad.
the so-called control of conventionality. So gives us
Y naturalmente que
naturally
esto se plantea
this is
como una
being
solución
presented as a
muy
solution,
inteligente, me parece a
a
mí,
very
de
intelligent
parte de la
solution
Corte,
that
que
is put by the court
está tratando de
that
involucrar
is tried to
en la defensa de los
involve
derechos humanos
in the defense of
a
human
todas
rights,
las autoridades
all
de
the
todos los
authority
estados,
of all the states,
imponiéndoles el deber
imposing to them
de
the right
vigilar
to be vigilant
la violación de
on
los derechos
violation of human rights
en cualquier momento
and at
en el
any moment
desarrollo de los
in-
gobiernos
in the
o en el
development of the
desarrollo de la
governments
actividad legislativa.
or in the development of legislative
Y esto me
procedures.
lleva a una
activities.
reflexión.
And this gives me a final reflection.
Yo creo
I believe that
que tenemos que
we have to
darle a
give
la judicatura, es decir, al sistema
we have to
judicial
give to the
de nuestros países
to the justice
la
system in our countries. We have to
misión
give them the mission, the vision
de velar
to
por los derechos humanos
be able
como una
to
tarea
take care of,
primordial.
to be vigilant to human rights as their main task,
Entre las funciones del Estado,
as one of the functions of the state,
la función de gobierno
and the function
corresponde
of government
a los poderes activos,
it
la
corresponds to the
administración
active
y la
powers,
legislación.
the administration and
Y los poderes
legislation,
de garantía
and the power
corresponden
that
a
do
lo que se ha
this
llamado
guarantee
la administración inactiva, o sea,
correspond to the inactive
a la
administration,
judicatura, a los
I mean,
tribunales de
and
justicia.
then to the tribunal justice tribunals.
Entonces,
So
la Corte Suprema, perdón, la Corte Interamericana
and the Inter-American Court of Human Rights
ha entendido
has
esta
understood
diferencia
this difference
y ha tratado
and
de
has tried
colocar
to place themselves
sobre la cabeza de los
and to
jueces
place in the
la
heads of the
responsabilidad
judges
directa
the direct
por
responsibility
la vigencia de los derechos humanos.
to make sure that they protect human rights.
Creo que en América Latina
I believe that in
nunca
Latin America,
le otorgamos a la figura del juez
never we
el
give
papel
to the
primordial
judge
que tiene en lo que se refiere
protagonist role
al control de
and what
los
I mean
actos de los poderes
and
políticos
the control of
y a la
political
tutela
acts
de los derechos humanos.
and the cohesion of human rights.
Por mucho tiempo
For
no entendimos la importancia de
for many years,
reforzar
we didn't
institucionalmente
the
en
importance
cada
of
país la
reinforcing the
formación y el
institution
desempeño de
and the
jueces doctos,
creation and the
independientes
preferment
e
of
imparciales
judges that
para
are
asegurar la
independent and
estabilidad
impartial to
institucional del
assure
Estado
the
y una
institutional
efectiva
security of the state
garantía
and
de la
create
vigencia
an
de los
effective
derechos
guarantee
humanos.
of the existence of human
La
rights.
Comisión y la Corte
The
Interamericana
Commission and the Inter-American
han
Court
tratado de suplir
have tried to
con grandes
provide
dificultades
with
y
many
experimentando
difficulty,
grandes demoras las
experiencing a
graves
lot of
deficiencias en la función de
delay
garantía de
to
parte de la
actually
judicatura de
provide
los estados.
the guarantee of this
Pero
process and
por
many of the
mucho
states
esfuerzo
for as
que hayan
much
hecho,
efforts that they have done,
los medios de los que disponen la Comisión y la Corte
the means
son
that the Commission and the Court have
notoriamente
are
insuficientes
not enough
para cumplir
to be
adecuadamente
able
su
to
propósito
uh,
de una
be able
tutela
to
efectiva
do a
de los derechos
complete
humanos.
and deal with a complete
En
purpose
vista de
of
ello,
addressing human rights
la
violation.
Corte Interamericana ha desarrollado
With
la
that
doctrina
in
del control de
perspective,
convencionalidad
the
que
court
he
has
tratado de
developed
explicar
the
aquí,
doctrine of
cuyo sentido es
control
poner en las
conventionality
manos de las
that have
autoridades
tried
de
to
cada
explain
estado
here
y
with a
particularmente
purpose
de
to
los
place it in the
jueces
hands of
la
authority of each
función
state,
de garantizar
particularly
los
in judges,
principios y normas de
with
la
the
Convención
function of
Americana
guaranteeing the principles and norms of the American
contra
Convention of
las
Human Rights
actuaciones arbitrarias y abusivas de los
against
poderes públicos,
arbitrary and
bajo la
abusive
mirada
actions
orientadora y
by the
vigilante
public
de la
commission
propia Comisión
under the
y de
guiding
la
and vigilant
Corte.
gaze of the
Claro,
Commission of and the Court.
no es lo mismo
It is skill.
para la Corte y la Comisión actuar
Is
como
the
órganos
same to our
aislados,
as
externos a
isolated
los países,
and external bodies.
que contar con la colaboración de las autoridades públicas de los estados y sobre todo con la colaboración de los jueces internos
With the collaboration of the internal judges,
a fin de cumplir la delicada
with the
y
purpose
esencial
of complying
tarea
with the delicate
de
and
tutelar los
essential
derechos
duty or
ciudadanos.
task of promoting
Ahora bien,
uh,
para mi criterio,
and ruling over
queda
the
claro
citizens' rights.
que la verdadera clave
Now, for me,
para un potente
clear
sistema de derechos humanos
the true
es
key
una
for a
judicatura docta,
potent human
independiente
rights system
e imparcial
is
en
a
cada uno de
strong,
nuestros países.
independent, and
Ni la
impartial
Corte ni la Comisión
judicial system
por sí
in our
mismas
country.
pueden resolver el problema de los derechos
They
humanos.
can work.
En este
the organisms
sentido,
themselves
la
can solve the
doctrina
human rights problems.
del control de
In this
convencionalidad
sense,
que ha desarrollado
conventional
Corte Interamericana
cultural doctrine that has been developed
proyecta
by the
una solución
Inter-American
realista,
Convention,
pero a la
develops
vez,
a realist solution,
demanda
but
de
at the
parte de los
same
estados
time it demands from the
un
states
esfuerzo enorme
a huge effort
por institucionalizar
to
una justicia
institutionalize a justice
docta, independiente
that is
e imparcial.
real,
Muchas
independent,
gracias.
and impartial. Thank you very much.
Thank you very much, Walter, for that very sweeping explanation of the history and the functioning. I think that one of the things that I took many positive things out of this, the successes of the court. On the other hand, the overwhelm of the court, that the court and the commission can't possibly handle the number of cases that come before it. The fact that member states the judges in domestic courts in member states are expected to apply not only the terms of the American Convention on Human Rights, but also the jurisprudence determined by the court and the commission. And so I thank you very much for that. And I apologize for the lapse in interpretation for the people watching. And perhaps in the week or so, we'll have a transcript online that will be able to clarify things that are unclear because of the lapse in translation. And now I would like to give the floor and the screen to Stanislav Ajong to talk about the African Union system. Stanislav?
Thank you very much, Claire. Now our attention will be drawn to practicing before the African Commission on Human and People's Rights and the African Court on Human and People's Rights. It's important for us to note that the African system has a number of organs that are charged with managing the human rights situation. This will include ECOWAS, as Bill mentioned before. We have the East African Court. We have the Southern African Court. We do have the CEMAC Court and other organs, which all in their own rights manage the human rights situation and violations in Africa. However, for today, we shall limit our discussion to practicing before the African Commission on Human and People's Rights and the African Court on Human and People's Rights. We have to note that practicing before these two organs is open to any person anywhere around the globe. We'll come to see that as per the rules contained in these two organs. Also, it's very important to note that practicing before these two organs is codified. So you have to be abreast with all the rules governing practice, that is seizure of the system, right through to hearing and enforcement. There is no room for conjecture or creation. You have to follow the rules or the law as the case may be. For us to better understand and get our feet moving in practicing before this commission, we sent out 5 links. These links include the African Charter, the rules of procedure before the African Commission on Human and People's Rights, the African Court, the protocol to establish the African Court, and the rules of the African Court. These links are not exhaustive. These are just important ones that we want to work on today, which will help you if you have to practice before either of these organs. But you have to note that the African Commission, which I just referred to as the Commission, and the Court will just refer to as the Court. The Commission and the Court are both organs of the AU, which is a sub-organ of the UN. And if you have to practice before these two courts, you should not be limited to the links that we have shared today. This is so because we will come to realize that when there are violations, you can bring action against the state party who has ratified and acceded to other international treaties and conventions. This will include the Universal Declaration of Human Rights, the Covenant on Civil and Political Rights, all the international conventions ratified by member states of the African Union. Where there are violations, you can cite those international instruments before the Commission and before the Court. That said, I will start now with the Commission, and we shall later move to the Court, and we'll make a conclusion regarding the relationship between the Commission and the Court. In this case, if we want to get to the Commission, it's important for us to know the background to these organs coming into place. You have to be aware that the African system has a history which is both ancient and recent. In terms of the human rights system, it is fairly recent if we have to compare it to the European and the inter-American systems. The African Commission came into being in 1987, the Court in 2004. These are fairly recent creations. But as I say, the background to all of this is that under international human rights law, the idea is protecting individuals from state intrusion. For this, there have to be access to justice for victims or perceived victims of state encroachment into the life of individuals. As I earlier said, at the African regional level, we have this commission and the court and many other regional sub-organs to manage these violations or perceived violations as the case may be. We move in Africa from colonialism. We have a history of colonialism. And we have a situation now which is described like the colonialists left and the colonialists took over. This is just a change of the name of the violators. Because we are now talking to progressive and anti-imperialist lawyers and activists, which are principally centered around functioning as counsel for the complainant or the applicant, as the case may be, because we have to know that the states also have the rights to bring actions against other states in the two organs. But our discussion was centered mostly around functioning as counsel for the alleged victims of state intrusion to their individual lives. For the Commission, you have to be aware that you must go through the African Charter, which directs how the Commission functions. Because of practicing, the Charter brought up the provision to create the rules of procedure before the Commission. And these rules of procedure have moved a number of times, and the most active one now are the rules of 2020. You have, as I earlier stated, the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights. But please, if you have to have a successful practice before the Commission, you have to have the Charter at your breast, because the Charter directs operations and the rules direct how you seize the Commission, how cases are handled, and how it is concluded, what is a decision on the merits. And before you get to the Commission, how do you go? You have to start. How do you start this? First, gather your facts. It's important to gather your facts. Then you research on the laws violated. This is important because every fact has to be related to a violated law. If there is no law that is violated, the fact stands for nothing before the Commission. It's important for you to consider the status of the state party that you bring in the action against. Is it signatory to the Charter? Has it ratified the Charter? It's also very important for you to consider the parties of the action. We'll come to see that the parties is very important because it is mentioned in the rules of procedure. You have to check out if local avenues have been exhausted before seizing the Commission. This has come up in practically every communication that has been handled by the African Commission. The state parties always seem to want to rely on a provision in the Charter and in the rules of procedure, which checks out that local avenues must be exhausted before you seize the Commission. But we'll come to examine that in detail. Then you have to compose your complaint. The rules give some guidelines on how your complaint is supposed to look like. Then you have to file the complaint. When you file the complaint, that is not all. Before the African Commission, you have to follow up. I'm speaking in a personal capacity where I've had a communication that was listed for hearing before the Commission, Banjul, the Gambia. I traveled from Cameroon to Gambia And upon arriving Banjul, I saw that my communication was not listed. I had to move from office to office. And during that session, the communication had to come up simply because I made the displacement. Sometimes it will be said that there is no cost in filing before the commission, but the incidental costs are definitely enormous. So it's important that you follow up with your complaint. Next step, when I talk of guarding your facts, I will refer participants to Article 2 of the Charter, those 5 links that I sent out. Please, if you can open the Charter and look at Article 2. I talked with Erin the other time to see if there's a possibility for us to just read out some of these articles so that we can have a better understanding of how to carry on our practice before these institutions. If there is no one who can read out Article 2 for us, I would attempt to read it. Let me just get to the charter. And got this. Oh, I read my screen is blocked. I cannot get through to my resources again. Okay, thank you. I get it. Thank you very much. Okay, let me just get through to the African Charter. If you can open it up yourself and we look at it together. Let's just read Article 2 of that Charter. It states, every individual shall be entitled to the enjoyment of the rights and freedoms recognized and guaranteed in the present charter without distinction of any kind, such as race, ethnic group, color, sex, language, religion, political, or any other opinion, national and social origin, fortune, birth, or any status. So, participants, as you can see, this is quite enormous and covers a lot of ground. So, when you gather in your facts, you have to look at all of these aspects that are contained in Article 2 and see which of these have been violated that you're seeking for the courts or the commission's intervention. It's very important for you to have the dates of the events noted. It's very important. It's also very important for you to get an idea of and establish the idea of the relationship the complainants have to the alleged violations. I have a case study that we would like to use in this particular discussion to examine the case of how the facts are gathered and related to the laws that are violated. This is communication 266/03. That's Kevin Gwanga Gumne against Cameroon. For those who can access it. You will have your private time. You will look at it. For in this communication, the complainants in this case complained of violations of Article 2, Article 3, Article 4, Article 5, Article 6, Article 7, Article 9, Article 10, Article 11, Article 12, Article 13, 17, 19, 20, 21, 22, 23, and 24 of the African Charter. So you are not limited in any way in presenting your facts in relation to the laws that have been violated. In fact, you are encouraged to make sure that you identify all the facts and go through the African Charter section by section to see which particular law has been violated. Once you do that, you can now progress. Erin, can I come back to my screen? You can now progress to the next stage of getting your claim through. This is you research on the various laws that have been violated. You have from Article 1 all through to Article 26 of the Charter. All of these articles cover a vast span of your living. It goes right from development, electioneering, to natural resources. So there is every little part of your life that you live that if you believe that there is a violation occasioned by the state party, you have the right to bring it before the commission. And in this case, it's also important that we take a very close look at Articles 60 and 61 of the Charter. If you have been able to open up those links and you are on the Charter, I will just pray you to go to Article 60 and take a close look at it. You also look at 61 and see what it says. When you have researched, you have carried out your entire research, you have seen the sections of the law, the sections of the Charter. I still insist that is the sections of the Charter that have been violated. You match them with your facts. The next thing you have to do is to check if the state party is a part of the AU or has ratified the Charter. This is easy to check out. If you go on to the site of the African Commission on Human and People's Rights, you'll be able to check the table of countries that have ratified the Charter. In this case, Article 65 is again important. It's important that all of us take a look at it again, and then you would see what the Charter says in these circumstances. As I said, the law is codified. You just walk step by step with the provisions of the Charter. Once you do this, you will be able to successfully manage your complaint before the commission. Once that is done, most important, You have to look at the local standard. What is the local standard of the complainant? This is crucial because the commission, the rules of commission have said it, the African Charter has stated it, the rules have stated it. You have to state your identity, who you are. And this must be defended and clarified before the commission. You have to check on the state party, be sure that the state party is a member of the AU, ratify the charter, and then you go down to Article 56 of the charter. Now, Article 56 is crucial when you are constraining the parties to an action before the commission. It says, and I would like us to read it again, communications relating to human and people's rights referred to in Article 55, referred by the commission, received by the commission, shall be considered if, one, they indicate their authors, even if the latter requests anonymity. So we're talking of the author, your name must be stated. You must indicate your names. You can say you want to be anonymous, but then the commission should know your names. If they are compatible with the Charter of the Organization of African Unity, this should be the AU, or with the present charter, are not written in disparaging or insulting language directed against the state concerned and its institutions, or to the Organization of African Unity, that is the AU, are not based exclusively on news disseminated through the mass media, are sent after exhausting local remedies, if any, unless it is obvious that this procedure is unduly prolonged, are submitted within a reasonable period from the time local remedies are exhausted or from the date the commission is seized with the matter, and do not deal with cases which have been settled by those states involved in accordance with the principles of the Charter of the United Nations or the Charter of the Organization of African Unity or the provisions of the present charter. So as I earlier stated, the commission is not severed from the United Nations because of it is a member of the AU. If the parties have had their matters settled by a United Nations organ, the commission will not handle it based on this last provision of section Article 56 of the Charter. Now, once we do all of this, we come back and make sure that local avenues have been exhausted. This has been a thorny issue because I will give you as an example, secession is criminalized under the Cameroonian law. It's a crime to talk of secession or mention things that concern secession. It's considered as a law on anti-terrorism. You are considered as a terrorist if you mention secession. But under international law, secession is considered as an expression of freedom of expression. It's just an expression. You can use other legal avenues to see if you can attain the goal of seceding or not. Now, if you have an action for self-determination, for example, against the state of Cameroon, Article 56 says you should show proof that you exhausted local remedies. But if you attempt to exhaust local remedies in Cameroon in the case of fighting for secession, as a remedy which is provided for under the charter, you cannot have it because you'll be prosecuted, because it's a criminal offense to mention secession by the local laws. In this case, you don't have the avenue to exhaust local, you don't have that possibility to exhaust the local avenues because secession will not be entertained in any court in Cameroon. Once you can prove that, you would have been able to answer the question, are sent after exhausting local remedies, if any. They have said there, if any, because if any is a window that has opened up for litigants to be able to exploit it. And you, as an advocate for the complainant, should be able to look at the local laws to see if there are impediments to the exhaustion of local remedies on the violations that you are bringing before the commission. So I just gave you this example of secession. There are many other examples that you can cite for other countries based on other local legislation. And it also states that unless it is obvious that this procedure is unduly prolonged, that is another arm of it, where if the courts, the local courts, continuously adjourn your case, the courts do not have independence, they lean on the executive and will not listen to you, would keep you rigmaroling, taking you forward and backward, taking from one court to the other with no resolution in the near future. You would have been able to demonstrate to the commission that you cannot exhaust local remedy, and your commission, your communication will be available to be heard on admissibility. Most important, when composing your complaint, you have to take into account Article 56. You have to take into account your language. The language has to be simple, clear, and concise. You have to remember that members of the commission are elected, are presented by state parties and elected. There is no qualification which says that this must be judicially trained persons. So you have to make your language to be such that they can easily, any person can easily understand. And Article 56 says it should not be disparaging and insulting. And then while doing this, we have to consider the functions of the commission, which is to promote, to protect, and to interpret. So you have to see what you're looking for. Are you taking to get protection for your clients, for the persons you are advocating for? Are you seeking for promotion of their rights? Or are you seeking for interpretation of some laws, cases that are detrimental to the persons you are representing? Once you get all of this in place, it is now good for you to file your complaint. How do you file it? You have to send it to the Secretariat of the Commission. Once they receive it, they have their procedures. It's laid down in the 2020 procedure, which they will follow up. But most importantly, after this has been received, you have to follow up. Your follow-up, what do you have to do? You have to get to know the general principles on the sessions. You have to know that there are ordinary sessions, there are general extraordinary sessions, and you have to note that there is an order of consideration of communications. All of these are contained in the rules. It is well spelled out. You have Rule 27, Rule 28, Rule 29, Rule 96. And most important, you have to give your contact to the Secretariat. They should be able to reach you by email, by phone. Also, there are a number of non-governmental organizations that are affiliated to the Commission. It's important that you register your email with them, because when there are extraordinary sessions or the ordinary sessions, dates are changed, those NGOs quickly get that information and they share to their members. If you are part of them, you will get the information. And most important, you have to note when you're taking up your communication with the Commission, is that there are no rules for enforcement. The decisions that come out of the commission are called recommendations. These recommendations are given to the state party and advised to follow. There are no rules which give the commission to be able to enforce these recommendations on the defaulting state party. But what they do is they do send out communications reminding them of their obligations to abide by by their engagements, by their obligations. At the end of the day, you have to be astute and make sure you follow up with the commission to get through the secretariat to write back to the adjudged state party to abide by the recommendations that they make in favor of your clearance. That said, let us quickly run through the court, as I can see that my time is running out. The African Court is also managed by the African Charter. There is the protocol to the African Charter on the Human and People's Rights to establish the African Court on Human and People's Rights. This court is based in Arusha, Tanzania. Bill earlier said it. And this court is also managed based on coded laws. We have the rules of the court. These rules of the court, we have the site, the link I've sent out. When you go through to that link and you open the African Court, you will see a section that tells you how to file a case. And I have to acknowledge here that I've sent out this slide that we're following up today, that I've got a chart from the site which gives us step-by-step procedure on how to file a case before the court, and also gives us a step-by-step procedure on the follow-up. So getting started with the court, you have to just make sure that you follow step one. Has the respondent state ratified the protocol? First things first, if it is no, then there is no case. You stop there. If it is yes, the next question you ask is, are you an individual or an NGO, state, or African international non-governmental organization? We talk of individuals and NGO. You are an individual and NGO. The next question is, has the respondent state deposited the special declaration? The special declaration is for the African state to be able to say that individuals and NGOs can file against them. If they have not, you have to go to the commission. You have to go to the commission, and the commission will be able to file a case for you. In this case, you have to convince the commission that you want your case to go to the court because you are thinking of enforcement. The commission does not have enforcement rules, but the court has better enforcement procedures. Now, if the state has deposited a special declaration as contained in the rules, then you send your application directly to the court. And you can, in that case, request for legal aid if need be. If you think that you really need legal aid, you can ask for it. Then the case will now enter into the court, and the court will start managing your case. Again, you have to think of legal representation. Article 5 tells us who can institute an action. That is on the protocol to establish the court. Article 5 tells us who can institute an action. And if we open that protocol and we look at Article 5, we can look at it together. Article 5 reads, access to the court. The following are entitled to submit cases to the court: the commission, the state party which has lodged a complaint to the commission, the state party which against which the complaint has been lodged at the commission, the state party whose citizen is a victim of human rights violation, and the African intergovernmental organizations. And when you go through all of this, you will see here that the court may entitle relevant non-governmental organizations with observer status before the commission and individuals to institute cases directly before it in accordance with Article 34 sub 6 of this protocol. Now, Article 34 sub 6 is special. This is a declaration from the state party, which allows NGOs and individuals to file cases against them. But what is happening now is that states are filing the declarations. After sometimes they see good cases, a number of cases coming against them, they go and withdraw. But the good side of it is that once you file and the case is there, you withdraw, the case will continue. So we'll have to look at rules 39, 40, and 41 on access to the court. And then we have to take a critical look at Rule 50 on admissibility, which is a repeat of Article 56 of the Charter. Now, you have to still follow up your complaint at the level of the court, because you have to see how the case is progressing. Once the application is before the court, the registrar checks if all necessary documents are provided. The respondent state will have to reply to this, and then the applicant receives the state's reply. Then hearings are held in the court's decision or request at the request of the parties. The judges deliver judgment within 90 days, and then the court notifies the parties about the decision, and the respondent state has to take necessary measures for implementation, and the respondent state submits a report to the court to prove implementation of the decision. That is the crucial part of it, because that is the big difference with the commission, where the commission does not have enforcement procedures. Now, we have a case, a particular case, the Ladislas Chalula against the United Republic of Tanzania. This case was decided on the 5th of February. Anybody who has the time to look at it, and you will see all the steps and the arguments on jurisdiction, which were canvassed and argued before that court, and the court dealt with all of them. Now, to conclude, I see my time is already up, if I'm not mistaken. We have to know the relationship between the court and the commission. And for us to understand this relationship, we will have to look at Article 2 of the protocol to create the African Court. This Article 2 states relationship between the court and the commission. The court shall, bearing in mind the provisions of this protocol, complement the protective mandate of the African Commission on Human and People's Rights, hereinafter referred to as the Commission, conferred upon it by the African Charter on Human and People's Rights, hereunto referred as the court. So that is a summary within the 40 minutes, except my time, I still have some time there. That is a summary of how you can successfully practice before these two commissions. There is a commission and the court, the African system today. Hi, girl. Do I still have some time?
Thank you very, very much, Stanislaus, for giving that template of how to do a proper job before the commission and before the African court, how to get your case properly started. And I hope that you'll let us put the PDF of your slides on our website so people can use that as a guide. Now, the next few minutes, we've got 25 minutes left, and I'd like to spend about 15 of that time commenting on each other's presentations or questioning them. I don't know if one of the I'm not part of this, but I don't know if one of the things you might want to comment on or suggest is in this period of the global collapse of democratic governance and rights-based governance, do the regional organizations have any power here to stop that collapse or remedy it? Okay. But I don't want to, but you ask whatever you want. Go ahead. Who wants to go first? Do you want to go first, Bill?
Okay, I mean, I'm happy to try to answer your question. And the thing is, I mean, the short answer is no power, of course. And the Council of Europe and the European Convention are now in this situation where Russia has been expelled because of its illegal actions in relation to Ukraine. But there's also a war going on between two other member states, Azerbaijan and Armenia, where Azerbaijan is supported by Turkey, which is a member of the Council of Europe, and Armenia was supported by Russia, but Russia basically dropped them under the bus. And Russia's got quite serious problems with its former allies. But it's a dreadful situation for the Council of Europe. And of course, the United Kingdom, if, as seems likely, at the next general election, which is 4 years, if not earlier, the Reform Party UK, which is the Trump party in England, in Britain, if they win, then one of the things they will do almost immediately is to take Britain out of the Council of Europe and the European Convention on Human Rights, something which the Conservative Party already wanted to do quite badly. And I think given that the Council of Europe and the Court are very badly underfunded compared with the European Union's Court of Justice or the International Criminal Court, or the International Criminal Court at The Hague and the European Union Court of Justice in Luxembourg, I think they've already suffered a massive blow because of the absence of Russia paying its share. And I think if Britain was to leave as well, that would really put the whole thing into serious jeopardy. But what I just want to add to that is that I don't think that lawyers change the world. I'm sorry about that. I mean, being a lawyer myself, I think we can be useful. And I think what both Stanislaus and Walter have told us is ways in which well-qualified lawyers who know what they're doing can do really useful things. But I'm afraid to say that we do not bring about peace on earth or global justice, you know, and at the end of the day, it's only the people themselves who can do that. And in the United States in particular, many people are running to the courts at the moment, but there's a problem, which is that the Supreme Court is people appointed by Trump. So I think it's the people as a whole in the United States who will decide these issues, as it is and will be in Africa and in the Americas as a whole. So I just said, you know, I think anyone who thinks that lawyers actually bring about change is sadly mistaken.
Mhm. And Walter, do you have some comments to make? Questions to ask? I think you're muted, Walter.
Sí.
There you go.
Quiero saber si puedo tener la interpretación para conocer exactamente cuáles aspectos de mi conferencia han sido más interesantes para nuestros participantes. Y yo con mucho gusto me refiero a cualquier aspecto que estas personas quisieran saber. Pero necesito el intérprete.
Stanislaus?
Yes, I've learned a lot from our presentation from Bill and Walter, and I know now that there are the challenges all the jurisdictions have their different challenges, but Africa is peculiar. As I said, our own challenges range from even enforcement to where talk of things like elections, where people are suggesting that electoral fraud should be categorized as crimes against humanity because they take a different level in Africa. Sometimes people say corruption should also be categorized as crimes against humanity because the scale in Africa is different. Then when we have the human rights systems, we don't readily give you an answer at the end of the day. That is also the challenges that we have, and I'm good to learn from Bill and Walter what transpires in Europe and inter-America.
Well, should we open it up to questions from the people, the participants? Here's a question for Bill. Why didn't Ireland take their case to the ICJ?
So it was a human rights case, and the international. Sorry.
Yes. Okay. Carry on. Yeah.
Okay. It was a human rights case, of course, and the International Court of Justice is the court of the United Nations, and so Ireland could bring a case against the United Kingdom at the International Court of Justice, and of course, we have the recent example of South Africa bringing the case in relation to Israel. But for sure, the case which the Republic of Ireland brought achieved, in a way, the needed result, which was condemning the United Kingdom for torture and then inhuman and degrading treatment. And I don't think it would have been possible to get such a result in such a relatively short space of time at The Hague with the International Court of Justice. So these days we are seeing more cases at the ICJ relating, for example, to genocide. But genocide, of course, is not something which the European Court of Human Rights could deal with. And I'm not sure that the International Court of Justice would be the right place to bring allegations of torture. So I think the Republic of Ireland did the right thing.
Thank you. Walter, a question for you. I note in your presentation that the use of the convention doctrine has shown good success. How do you see this approach continuing in the next 5 to 10 years?
¿Me podrían traducir la pregunta al español?
Oh, can I translate the question? Perhaps the translator can. You said in your presentation that the use of the convention doctrine has shown good success. How do you see this approach continuing in the next 5 to 10 years?